Hello everyone and welcome to today's webinar. We've got a great presentation lined up for you today, but before we get started, there are just a few general admin points to cover. First and foremost, please use the online question tool to post any questions that you have and we will share them with our speakers. We will do our best to get around to those questions at the end of the session. Secondly, if you experience any technical difficulties today, please let us know using that same questions tool and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded and we'll be sharing a copy of the recording with you via email in the coming days. So without further ado, I'd like to hand over to our speakers to get us started.
Thank you, Lucy. This is David Hall. I'm the Chief Marketing Officer here at HBL. Good afternoon or good morning, as the case may be for many of our listeners today. For those not familiar with HBL, we're a national boutique ERISA and employment law firm currently serving corporate clients in 35 states. Our calling card is and always has been proactive, responsive, relationship-driven counsel. All HBL attorneys have large law firm experience. We bring big firm impact with boutique value. Just last year, we were named to the Inc. 5000. We've been the fastest growing ERISA boutique firm in the country the last 4 years running. And since January 1st of 2018, we need to update our badge, by the way. We've abated and avoided directly for our plan sponsor clients more than $75 million in penalties. So a little bit of housekeeping. If you do have questions, we will not have time to take those live on the webinar. I urge you to send your questions to admin@hallbenefitslaw.com. All questions will be forwarded to our speakers and will receive a response. I would also encourage you that if you're interested in this topic, that you sign up on our website for our monthly HR alerts and details about upcoming speaking engagements. Our website is www.hallbenefitslaw.com, and you can find us on all of the socials listed on this slide. My direct number is on this slide. If you'd like to get in touch with an attorney directly, please give me a call and we will calendar some time for you with one of our team. Nancy, next slide, please. Our bread and butter for many years has been ERISA legal compliance, and we're incredibly excited that recently we added Nancy Pridgen and Leslie Bassett to our team as of counsel. They bring ERISA litigation capabilities to complement our suite of services for our plan sponsor clients. So I'm excited for Nancy to introduce herself and Leslie to you. Again, I couldn't be more excited for this presentation. Nancy, take it away.
Thank you, David. Just a couple of introduction points for Leslie and I. We, as David said, we do have large law firm experience. Between us, we have 40 years of combined legal experience. We both began our foray into ERISA litigation at the Alston & Bird ERISA litigation group many moons ago. We were there for many years doing complex litigation on behalf of plan sponsors, plan fiduciaries, defending those cases. And when we departed from Alston & Bird, I continued my ERISA litigation practice at boutique firms like Hall Benefits Law, and Leslie went on to King & Spalding, where she continued to defend plan sponsors and plan fiduciaries. So we know a little bit about litigation, and certainly ERISA litigation between us, and our knowledge is both deep and wide. So we've got a lot of information we're going to share with you today, and just wanted to tell everybody to buckle up because we're going to try to make it through all of the slides that we have today. So without further ado, I will let you know that we're going to be talking about current trends in ERISA litigation filings and decisions. And then Leslie's going to take it away for best practices in fiduciary governance and benefits administration. And then if we can get to the questions at the end of the presentation, we will do that. So sometimes in order to know what what you should be doing in benefits administration or fiduciary governance, you need to know what not to do. And so we did a survey of the most recently filed ERISA litigation cases nationwide over the last 12 months. And we saw some patterns there, so we wanted to let you know sort of where the litigation is heading. There's over 2,500 new cases just in the last 12 months. Over half of those were insured welfare benefit claims. So your health, your life, your AD&D, and your disability claims. There were about 60 pension benefit claims, most of those retirement benefits, some of those retiree welfare benefits. Additionally, there were lots of life insurance interpleaders. And those, just for those who don't know, an interpleader action is one where the insurer usually goes into federal court and says, we have a benefit of, let's say $1 million. We don't know who to give it to. We want to give it to you, court, and have you decide to whom it belongs. And then they exit from the interpleader. And so, as you might guess, life insurance claims are certainly, ripe for these types of disputes, involving, lots of them involve quadros with ex-spouses or alleged quadros, and many cases involve what we call the Slayer statute cases, which is legislation across the country that says if you kill somebody, you can't take their life insurance. So those are always factually interesting cases, but there's quite a few. There were quite a few filed in the last 12 months. Additionally, before we move on to the next slide, we have seen an uptick in COVID cases. There were certainly some cases where COVID is alleged to be the disability that is preventing an employee from performing his or her work. Those are trickling, making their way through the court system. There was also, interestingly, a short-term disability case where the insurer denied a benefit claim as untimely, even though the Department of Labor's regulatory times for filing claims was extended during COVID. So we've got, apparently some folks didn't get the memo on deadline extensions, and we're denying those claims. So in addition to benefits claims, we find quite a few withdrawal liability and delinquent contribution claims still flooding the courts. Of the 2,500, a full third of those were delinquent contributions, withdrawal liability cases. Additionally, there remain a bunch of breach of fiduciary duty litigation allegations, excessive fee cases. There are quite a few excessive fee filings in the last 12 months, many of them against very large jumbo plans, including Kroger and some others. There are also lots of other notable breach of fiduciary duty complaints. Some of those involve 401k mapping errors. Some involve what we would colloquially call the stock drop cases, which are imprudent investment in company stock cases. Those are less than they used to be in previous years because of the case law that has come down, sort of making pleading one of those a little more difficult than it used to be, and also because of the market. So other notable fiduciary breach cases were filed by the Department of Labor. This is something that attendees should want to know. Where's the Department of Labor headed with their enforcement litigation? They filed about 15 cases in the last 12 months. 10 of those were related to defined contribution plans having unremitted or late remitted funds. So lots of, enforcement actions related to not getting those contributions and deferrals into the plan quickly enough. There were a couple of cases from the DOL that where they had to shut down abandoned 401k plans. And there were also some challenged ESOP transactions, including some private litigation as well in the ESOP world. But certainly the DOL is still focused on ESOP transactions and all of the issues that are present in those cases. In terms of other other fiduciary litigation, there were some pension cases. One where the plan was using a 50-year-old outdated mortality table with regard to the joint and survivor annuity. And so the allegation is that it wasn't actuarially equivalent because they're using the wrong mortality tables. There were a couple of interesting ones where a pension claimant was claiming a forged spousal consent form, and the plan was in the middle of that litigation. And another interesting case where brothers were suing each other over alleged breach of fiduciary duties with regard to taking personal use of pension funds, which, as we know, is a big no-no. But interesting allegations nonetheless. ERISA 510 claims, those are, as you know, related generally to retaliation or interference with benefits, retaliation for exercising a right under a benefit plan. Those account for about 2 filings a month, all private. None of those were the DOL. And there were a bunch of provider cases, large disputes, large-sized plan sponsor employers suing on behalf of their plan participants and beneficiaries against insurance companies for large systemic violations of insurance, and also providers, on the flip side, providers suing the insurance companies for denying large blocks of types of treatments that should have been covered. Additionally, the Mental Health Parity Act challenges continue at about one a month. Almost all of those in the last 12 months have been adolescent residential treatment being denied for lack of medical necessity, some wilderness and outdoor programs. But the challenges continue with regard to whether or not the plans are compliant with the Mental Health Parity Act, and whether they are compliant in practice and not just in name only. So we're going to next talk about the current trends in the ERISA litigation decisions. First, we'll talk about benefits, and then breach of fiduciary duty, procedural issues, and some other low-hanging fruit in terms of miscellaneous decisions. In disability plan litigation, as I mentioned, that's a large section, large swath of the cases being filed. These are just a few notable cases. Decisions have been, these are notable cases out of the circuits. There are lots of decisions. We couldn't possibly go over all of the decisions, but we just wanted to let you know sort of where the circuits are heading. So in the first one, Jet versus United of Omaha, really the takeaway there is the court was very explicit that the old regulations should have allowed the participant here to respond to new evidence that the insurance company created during the administrative process, and they didn't get a chance to do that. As we know, the new regs are explicit about that, but in this instance, this was about what the old regs required or allowed. In the next case, this is a disabled participant whose insurance disability benefits were denied both by the insurance company that he went out on and the insurance company that was in effect during his disability. What this brings up for plan sponsors and fiduciaries is you need to be thinking about what is happening with your disabled employees when you change carriers. So if you switch from one LTD carrier to another, there needs to be something in the plan that addresses that, even if their disabilities have not been granted yet, because they could be granted in the future. In the Bernard versus Kansas City 8th Circuit case, the takeaway from this is, a nurse anesthetist, I can't say that, addicted to fentanyl, was found to be absolutely disabled, and the court made a point of saying nobody can say that a nurse who's addicted to fentanyl is not disabled. That was sort of a categorical statement. This is likely to have more implication across, all employment types of issues for disability and not just LTD benefits. The next case in the 10th Circuit, the takeaway from this is actually sort of interesting because the plan language specified that the participant had to be, quote unquote, actually performing work to be eligible for benefits, and he became disabled during a layoff notice period. In other words, he wasn't actually performing work, but the court said, well, that's ambiguous, and we think he should be entitled to disability benefits anyway. And the last one on this slide, Maine's ban on discretionary clauses in health insurance plans doesn't apply to AD&D. That's sort of, it goes without saying, but it also doesn't apply to pension plans. There was another case where folks were arguing that the state's ban on discretionary clauses that generally show up in health and disability matters applied to AD&D or pension plans when they don't. Next, we're going to go to the life insurance litigation. A couple of these are interesting with regard to the very first one is with regard to MasterCard. The 8th Circuit revived some claims that the district court denied and dismissed based on misrepresentations about life insurance. So it is alive and well. There's a couple of the next couple of slides. Leslie and I were joking. There's a quote from a Supreme Court case that's about a dozen years old that says, quote, "People make mistakes, even administrators of ERISA plans," unquote. And we, as humorous as that is, we thought sometimes it should say, people make mistakes, even federal judges with lifetime tenure. The next couple of cases are evidence of that. In the 9th Circuit case in Workman, the court found that the California Insurance Code was to be interpreted to require interest on life insurance claims paid only if the participant had submitted a claim and payable from the date of the claim, even though the statute specifically says it's payable from the death of the participant. So not sure how the 9th Circuit reached that decision there. The next one, another 9th Circuit case, where the court seemed to want to reach a specific result and ruled that the employer had waived the evidence of insurability requirement in a life insurance policy as agent of the insurance company. Not only is that a bit dangerous in terms of agency law, but the court ignored the fact that there was a non-waiver provision in the policy and said that it was waived nonetheless. So slight problems with those. The next case, the estate of foster case, highlights that it's important when you have terminally ill employees, or if you happen to know about terminally ill, spouses or beneficiaries of plans, that HR needs to be cognizant of all of the benefits that can be affected by their terminal illness, life, disability for employees, and health plans as well. In this particular case, the court ruled it was a breach of fiduciary duty for the employer not to notify the terminally ill employee that he was going to lose his life insurance. And that was sometimes bad facts make bad case law, but nonetheless, folks need to be cognizant of that. And in the 10th Circuit, they've just decided that they're not going to institute a blanket duty to investigate rule. They said it's going to be case by case and depend on the facts in the particular case. So with that, we'll move to medical benefit claims, and I will give control over to Leslie and let her tell you about the next types of claims.
Sure. So I'm going to highlight some of the cases that are in these slides, but in the interest of getting to sort of the meat of what the best practices are that plan sponsors and fiduciaries can employ in order to minimize the chances of a litigation and the success of a participant on litigation, I'm going to go through these fairly quickly. In terms of medical benefit claims, this first case here, this Fifth Circuit case, it involves a denial of benefits for the plaintiff's minor daughter's claim for inpatient care for her 5th suicide attempt. And we're seeing more and more of these medical claims coming through the courts. The insurance companies, will allow certain periods of time for someone to receive inpatient care, and then they're requiring step-down care, meaning partial hospitalization or outpatient treatment. Especially under the Mental Health Parity Act, we're seeing a lot of these claims. In this case specifically, the insurer used, a guideline that allowed for them to deny the coverage based on the fact that it was acute inpatient care. It's really important to take a look at what guidelines your third-party administrators are using and compare those to the language in your plan that defines what's medically necessary. Because a lot of this litigation centers around the guidelines that are being used being more stringent than or different than the definition of medically necessary under the plan. Here, the Fifth Circuit got it right. The district court ruled that the participant should receive the benefits. I think that was the district court wanting to have a result rather than adhering to the deferential standard that's afforded to plans that have discretionary language in their plans. You know, you can compare that with this 10th Circuit decision. Here, the court relied on the actual the medical reviewer said that the medical treatment that the plaintiff was seeking was actually, you know, medically necessary without, you know, quote unquote medically necessary. And then the plan looked at it in terms of a medical guideline that was readily acceptable within the medical community and said, no, it's not proven. And the court upheld that because it's a rational basis for their decision. And then lastly, with the medical cases, you know, this case on Primera Blue Cross said that if your plan grants the plan administrator discretionary authority under the plan, then the participants have to be given notice of that. In this case, it was like the secret document that had the grant of discretion in it that was not provided to the participants either in the summary plan description or elsewhere. And so the court did not grant them the arbitrary and capricious standard of review, which is really key for plan sponsors and plan administrators in the benefit context. Nancy, next slide. I'm just going to highlight one pension benefit claim. And this one really is included for the idea that under ERISA, the plan says what it says, and the court's going to adhere to the language in the actual plan. Here, you know, the plan administrator read into the plan a term that wasn't there. The plaintiff was seeking supplemental early retirement benefits under a top hat plan, a SERP plan, and the plan administrator read into a plan sort of a requirement that the board had to vote in order to admit that person into a plan, where the plan's language basically said that they were eligible otherwise absent a vote. And the Second Circuit here said, no, you can't do that. The plan says what it says. Nancy, next slide. So the on retiree claims, you know, these are often, and I'm not going to go through these specifically, but these are often claims where retirees were promised over the years a certain level of benefits. Sometimes retiree medical for life, sometimes life insurance for life. A couple of those are here. And what the courts seem to seize on is if there is a reservation of rights in the plan document, which basically says we can amend or terminate the benefits under this plan at any time, then they're generally upholding those changes in benefits, even if there were ancillary promises made to the now retirees that they would receive those benefits for life. And then next is, hang on a sec, let me make sure. Breaches of fiduciary duty. Yep, okay, sorry. And I've just highlighted a couple of these here. One is this first one under the Second Circuit, the Massaro case. It's pretty simple, but it's something that we need to remember, which is, you know, if you are terminating or amending the terms of a plan, you're not acting in a fiduciary capacity. You're acting as the plan sponsor. And so those actions can't be the subject of a breach of fiduciary duty claim. And here, what happened was the plan administrators actually voted on the plan amendment, and regardless of whether that was improper, the court said it's a plan amendment, so there's no breach of fiduciary duty here. The next couple of cases, including this Varga case and the Baffert case, are, again, Nancy mentioned this, stock drop cases that really center around the sort of heightened pleading standard that was put forth in the Dudenhofer case. And it really requires for each of the plaintiffs to be able to plead that if the plan administrator had, disclosed certain information, that it wouldn't have been more detrimental to the participants than if they had not. And both of these cases here just sort of illustrate that the plaintiff's bar is having a very difficult time meeting that standard. So most of the motions to dismiss are being successful. And lastly, there's a Supreme Court case from January of this year that just sort of reaffirmed what Tibble said, which was, sorry. Okay, let me go back to the facts of this case. The facts of this case were there were like 400 funds in this, 401k's investment options. And so the plaintiffs sued saying, that's too many and we can't be charged with knowing how to deal with that. And the Supreme Court here said, you're kind of right, because at some point the plan sponsor, their duty to monitor requires them to remove imprudent funds. And we'll get to the duty of monitor again when we go through best practices. And then in terms of exhaustion, which is next, I think, is that right, Nancy? Yep. In terms of exhaustion, I mean, the only things to really note are that the exhaustion doctrine really is judicially made, and the courts are a little bit reticent to apply it in some circumstances, especially in this Ninth Circuit case, which finds against the plan sponsor where they blew the time limits. And some of the courts will seize that as an opportunity to revive a claim where otherwise it would have been required to exhaust the administrative process, and they failed to do so. And sometimes the court will say, well, the plan administrator blew the time limits, so we're going to give them what's really important for a plan sponsor, which is we're not going to give them an arbitrary and capricious standard of review, which is highly deferential to the plan sponsor. Instead, we're going to employ a de novo review, which is where the court just looks at the claim itself and decides on their own whether they agree or disagree that the participant is entitled to benefits.
Okay, thanks, Leslie. I'm going to do the next couple of slides. So with regard to arbitration clauses in plans, what plan sponsors and plan fiduciaries should know is generally these are going to be enforced. There are a few small exceptions. This Cooper case from the Second Circuit said that the employer's third-party investment advisor didn't get to compel arbitration under the breach of fiduciary duty claims brought by a plan participant, mainly because the third-party investment advisor is, not a party to the arbitration clause generally. And then the last one on this slide, the Seventh Circuit said ERISA cases are in fact arbitrable, but there was a plan-wide relief provision that the court found was unenforceable. In other words, that they couldn't make plan participants give up the right to seek plan-wide relief. A couple of miscellaneous cases before we jump into the best practices. These cases are notable. There's a Mental Health Parity Act case in this, which we've already talked about a little bit, so I'm not going to go over that. In terms of non-compete provisions, which we find in lots of top hat plans and severance plans that are not top hat plans, it's important to know that at least in the Third Circuit, those non-compete provisions are going to be enforced. The Wilson case was also important. The violation of the regulations, the violation of the regulations was reason enough in the Fourth Circuit to let the claims go forward for residential treatment. The administrator had failed to produce the documents for the claims filed in the administrative record, and the court said, no, you can't do that. The next one, forum selection clauses are generally going to be enforceable, or excuse me, they are nationwide. I've never seen a case that refused to enforce a forum selection clause. So they are enforceable generally nationwide. And finally, in the Festini case, this was an interesting case because the divorce decree, as lots of divorce decrees, similar divorce decrees, was not fully compliant with the quadro requirements, but the court said it was good enough anyway and let it go through. And that's a 10th Circuit case. It's not a district court case. So it's important for plan sponsors in that situation to understand that quadro, sometimes you got to give divorce decree the benefit of the doubt. But with that, I'm going to give it back over to Leslie, and she's going to talk about best practices.
Thanks. So couple of things that I want to talk about center on things that plan sponsors and fiduciaries can do to minimize either the likelihood of benefits disputes or their chances of succeeding in defending themselves in the event that a dispute does arise. And so the first kind of set of tips that I'm going to give you has to do with fiduciary governance. You know, plaintiffs, class action lawyers, and in ERISA lawsuits, the DOL, courts, and insurers have been kind of focusing increased attention on how well ERISA plan fiduciaries follow a procedural due process. And so in the case of fiduciary responsibility under ERISA, the core concepts can be kind of boiled down to three things. You're going to establish a prudent process for administering your benefits plans. You're going to adhere to that process, and you're going to document the process so that if it's questioned subsequently, then you'll be more likely to be able to defend the process that you used and its implementation. The principles really apply no matter what kind of benefit plan is involved. And the courts have really affirmed the strength and validity of these principles over time. For instance, you know, in the stock drop cases, in medical benefits cases, in life insurance cases, in terms of a plan sponsor and, sorry, not sponsor, but plan administrator and fiduciaries, you know, fulfillment of their fiduciary responsibilities. And just, I want you to remember that if the plan grants discretion to the plan administrator to determine eligibility for benefits and interpret the terms of the plan, then the plan administrator's determinations are entitled to that arbitrary and capricious deferential review, which generally means that the court's going to look at a determination on benefits and say, okay, well, do I agree with it? Is it right or wrong in my view? But even if it is wrong in my view, was it unreasonable? for the plan administrator to make that decision. And so it'll generally be upheld as long as it's reasonable. And here, that's where that process comes into place, because the process itself is an indicia of reasonability. So where do you start? So there's a lot of fiduciary responsibilities to implement with respect to all of these benefit plans, and nobody can really do it alone. So regardless of what size of employer you are, we recommend that there's a delegation of duty from the owner or the board of directors of fiduciary responsibilities to either individuals or committees to run the ERISA plans and fulfill the fiduciary duties. Even when you delegate those duties, the board or the owner, whoever the plan sponsor is, retains the ERISA fiduciary duty to monitor the activities of those individuals and committees that you delegate authority to. And we'll talk about that a little bit later and how to best optimize the way to do that. Also, it should just be noted that fiduciary delegations from the board to committees or individuals ought to be in writing, and you need to revisit them, fairly frequently, because they have to be kept up to date. And when corporate changes happen, you've got to amend or restate the actual delegations in order to keep them in line with what your corporation is doing. Certain situations give rise to that: corporate reorganizations, if a specific individual is named in a fiduciary, if they leave the company or the role, or if position names change. For instance, if you have like your HR director as a member of the Benefits Administration Committee, and that HR director title changes to something different, then you've got to amend these delegations. Next slide, Nancy. So, one thing you can do, and it's sort of the best practice that we would recommend, is to create committees that help with these fiduciary responsibilities and fulfill them. The benefits of having a committee is that you get all the right people in the right seats on the bus, meaning you get a diversity of backgrounds from, say, HR, finance, legal, that kind of stuff, on these committees that can provide different perspectives for thoughtful decisions. And again, nobody can do it alone, so committees are really the best practice. The number of committees that any specific employer is going to use to fulfill their fiduciary duties is going to be different depending on the employer size, the complexity of the plans, the number of the plans. But in general, there are 3 different buckets that these kind of fall into. One is the administrative committee, which oversees health and welfare plans and non-investment retirement plans. 2 is the investment committee, super important, monitors retirement plan investments and assets, and I'll go into a little bit of best practices on that in a second. And then there's the benefit appeals committee, which generally will review participant appeals of denials of benefits under the plans. One of the things, just going back to the delegations by the board, is it's very important for when the board or the owner delegates these duties to the committees to just be very specific in terms of what the duties that are being delegated are, which plans are covered, either categorically or by name, that kind of thing. And next slide, we're going to talk about charters, which is kind of how you define what your committee's duties actually are and how they're going to fulfill them. And this provides like a procedural safeguard against it. It shows that you've been thoughtful about defining these things and methodical in determining, how frequently you meet and all of that stuff. So a committee charter can really protect against inquiries into how or why a committee handled a specific sort of disputed situation. And they're really helpful in litigation, you know, for large companies in the past, either stock drop litigation or breach of fiduciary litigation that I've defended. You know, these documents, the committee charters and the minutes that we're going to talk about in a minute, and the PowerPoint deck slides that sort of are evidence of what a particular committee did in terms of process to ensure that they were fulfilling their fiduciary duties. That's what the plaintiff's lawyers are going to focus on. And we got to have our I's dotted and our T's crossed in order to make sure that we have the procedural protection of we implemented what we said we were going to do. So in terms of charters, what you want to include for sure in them is a description of the plans that the particular committee is responsible for, an allocation. Make sure that you're very clear about the allocation of duties among the committees. What's really helpful is to include a description of what types of committee members and what skills they need to have, either by title or by, you know, description. And then you need to have a description of how a committee actually takes an action. So what's the frequency with which they're going to meet? What's the voting majority? How do we pass, you know, an action? What quorum is required, and whether proxies are permitted. Those sorts of things need to be spelled out in the charters. And then what's also important to these committees is, you know, there are certain actions that they're responsible for that are administrative in nature and not actually really fiduciary. And they need to have in the charter an ability to delegate those out. Next slide. So in terms of the investment committee, now the investment committee and the investment committee's fiduciary role is super important with respect to retirement plans. And that's where we see a lot of the focus of this fee litigation and the stock drop cases and things like that. It's very helpful to have an investment policy statement. The standard on the investment committee and as fiduciaries is really high. It's that really of a prudent expert. So where if the committee members lack the requisite expertise to fulfill their duties, then they need to find it elsewhere in the form of, you know, a third party administrator, an investment advisor. And it's best practice to have, you know, you don't have to have an RFP process that's associated with that. But in terms of the committee fulfilling its responsibilities to sort of vet third-party vendors that are going to help with these investment decisions, it really makes sense for them to consider several options, to document what they've done, and to finally come down to at least 2 finalists. And then when it comes to plan administration, outsourcing the provider, you're likely to get a third-party administrator and record keeper, and they can perform tasks like submitting the plans form 5500, sending out mandatory notices and disclosures to plan participants, and the like. And the committee, back to the charter, needs to have the ability to delegate those responsibilities to a third-party administrator. Now we'll just talk about how you document the committee's actions, and that's through minutes, which are on the next slide. So the minutes are a little bit of a Goldilocks situation. Like, you don't want it to be too cold, you don't want it to be too hot, you want it to be just right. And so there's a balance and an art to making them useful, especially in terms of preventing disputes and defending yourself in litigation. You know, the minutes demonstrate the committee process, and they record their deliberation in carrying out their fiduciary duties. They're really scrutinized a lot, you know, well after the action that's the subject of the minutes is taken. And so it's important to be methodical in terms of what you put in them. One of the best practices that I can suggest in this situation is not to leave things dangling. Like if there's a question asked that's reflected in the minutes, then it needs to either be answered in the minutes, or there needs to be a plan for, you know, vetting it and getting it answered at a subsequent meeting. The minutes need to provide, you know, a description of votes generally. They don't need to reflect how each member voted or their rationale, but they need to reflect the count. And in terms of discussion about any particular issue, say your, you know, your investment menu, there should be a description of the discussion and who was involved, but it's a description high level and not a transcript of who said what, because that can subject those people to personal liability. As we know, fiduciary liability goes to the individuals as well. And then any materials that are reviewed by a committee need to be incorporated by reference in the minutes so that they can be part of them. And then I'm just going to quickly go over the next slide, which is training. You know, your fiduciaries need to be trained. Periodic training every 2 to 3 years. New people need to be trained. They need to understand the duties of prudence, loyalty, and diversification. You should document the content of the training. It doesn't have to be exhaustive of what was discussed, but at least, you know, the topics that were covered. And sort of one of the best practices in terms of creating continuity in a committee is to make sure that you rotate. You don't have like the majority of the committee coming off at the same time. So rotate when your people roll off the board and when new people come on. The next slide has to do with the board's duty to monitor. So even if you delegate fiduciary responsibility to all of these committees, the board or the owner still retains the responsibility to monitor the delegates' execution of what they've been tasked to do. So as we saw in this Hughes case that I talked about earlier in Tibble, it's really important to set forth a process to monitor. One of the ways that we do that, or that's best practices to do, is for each of the committees to give at least an annual report to the board of directors or the owners, summarizing the activities of their fiduciary committees. And those reports need to include sort of a description of the major activities related to the plans, big changes in funding or investment options, if the plans have changed due to mergers or any of that. Those are very important for them to focus on and make sure that those transitions are made smoothly, and that there aren't any claims that those are ripe for litigation when, you know, there's planned mergers or something like that, and the rights and for the participants are substantially different or different at all between the two plans. Plan terminations, the board should be aware about any changes in health and welfare plan benefits, third-party service providers, and all of that should go before the board so that they can see that the processes are being followed. It's really important to also for the committees to attach their minutes from the entire year and give those to the board so that they can so that they can fulfill their duty to monitor. The last topic that I wanted to discuss with plan sponsors and the audience here really is some best practices in benefits administration. And I know we only have a few minutes left, so I'm going to give you the high levels of some of these. And then, of course, if there are questions afterwards, I'm happy to discuss with any of the participants here. So ERISA requires a full and fair review of benefits claims. What does that mean? It means you need to have a process. It means you need to respond to the arguments and the questions of your plan participants. Again, I can't stress enough the importance of this deferential standard of review that applies if your plan has discretionary language in it. Getting a court to review your case under the arbitrary and capricious standard versus a de novo standard is key to, to your defense and your process in your benefits administration process can affect whether or not you are able to take advantage of that arbitrary and capricious standard. A couple of things you can do, next slide, in terms of things you can do to minimize your liability. Number one, ERISA doesn't have its own statute of limitations in it. And so the applicable sort of state court statute of limitation applies to claim for benefits generally under ERISA. And say, for instance, in Georgia, that's 6 years. But a plan can take a look at their plan and amend it to include its own contractual limitations period in a plan. And generally that's been upheld if it's like 1 year. What does that do? Well, if somebody rests on their rights for more than a year, then you're able to foreclose liability based on the statute of limitations that's in your plan. Let's see, you can also do the same thing, amend your plan to specify what the venue is where any litigation is going to be. And that can be helpful for a plan sponsor because you don't have to be litigating all over the country. Let's see, next slide. Some of the things you can do, you want to make sure that your benefits administrators know that communications, even email communications and things like that, can be construed as formal ERISA claims that need to be addressed under the claims under the claims regs and under that process. So you want to be alert to the way that your benefits administrators are responding to participant inquiries, and make sure that the communication to them is clear, that they're either responding to something as a request for information or as a claim for benefits, and then providing them with the information they need to make a claim if they need to. So it's really just about clear communication. And then, and I'll wrap up here in a second, we've got, in terms of benefits administration, and I think this is the next slide, making the record. It's super important for the plan sponsor, plan administrator to, that is reviewing benefits decisions, to respond to all of the arguments that are raised by a participant. What you're doing during the administrative record is creating a record of the decision-making process, and you want to do that with an eye toward what if this gets challenged in litigation. And so it's, in general, if an argument is not raised and answered in the benefits administration process, then it's not available to either party in litigation. So you want to make sure that your benefits administrators are very concise in the language they use, that they comply with the regulations, that they're professional in internal communications, and that they reflect all of their discussions in their committee minutes. And there's just one more thing that I think it's really important for plan administrators to understand is that there's a fiduciary exception to the attorney-client privilege that will apply to a lot of the communications between plan administrators and their legal counsel during the benefit claims process. And so ordinarily, you know, client and attorney communications are protected from disclosure under the attorney-client privilege. Well, because the plan fiduciaries are bound to act in the participant's best interest, this doctrine of fiduciary exception to the attorney-client privilege was developed, which basically says that the ultimate client is the participant. And so for a lot of the communications between an attorney and the plan administrators during the claims process, those could be discoverable in litigation. So plan administrators need to be super wary about what they're saying in their communications with their lawyers. I think we've run out of time, and I've got plenty more to say, but it's been really a great opportunity to talk with you guys today. I appreciate all of your participation. I think David mentioned that we'll be happy to answer any questions if you submit them to admin@hallbenefitslaw.com and to have follow-up discussions as necessary. Thanks for your participation today, and we will see you soon.